Okay, Courts of Justice, Deuteronomy 19. The Bible established specific procedures to be used in courtroom proceedings, and the objective of each was to secure justice. For example, Deuteronomy 19:15 through 18 stipulates, "A single witness shall not rise up against a man on account of iniquity or any sin which he has committed. On the evidence of 2 or 3 witnesses, a matter shall be confirmed. If a malicious witness rises up against a man to accuse him of wrongdoing, then both the men who have the dispute shall stand before the Lord, before the priests and the judges who will be in office in those days. The judges shall investigate thoroughly." Many other scriptures address courts, judges, and legal proceedings, and all appointed to the same purpose, securing justice. For additional passages on the judiciary, see the commentary accompanying Deuteronomy 10:17-6, Joshua 7, 1 Samuel 7, Proverbs 18:17, Isaiah 126, 2 Corinthians 3. Significantly, the due process clauses of the U.S. Constitution, the 4th through the 8th Amendments, also contain specific provisions to secure justice in court proceedings, and those provisions are based heavily on Bible teachings. This fact is affirmed even by modern Supreme Court justices, who are not at all considered religious, but who nevertheless make this acknowledgement simply because the history is conclusive. To learn more about how the Bible directly shaped the Constitution's due process clauses, see Federal Practices and Procedure, Federal Rules of Evidence. In the millennia preceding American colonization, courts had been used as a political enforcement machinery. Justice was definitely not their objective. In the 15th and 16th centuries, many of the dissenters, those who followed Bible teachings and opposed the corruption of state-run churches, had been tried, convicted, and punished by these tyrannical courts, and they began pointing out biblical passages that illustrated the proper use of courts. But after decades of continued judicial persecution and cruelty, and no success in securing judicial reform, large waves of dissenters departed Europe for America, specifically citing the judicial corruption of European courts as a reason for leaving. Upon their arrival, the dissenters took deliberate steps to ensure that the judicial system here excluded the problems and practices that had characterized the English judicial system. They believed that one of the most effective means of securing justice was by the use of juries, a practice largely excluded in Europe. Original jurors in America exercised powers far beyond those of modern jurors, who today often serve as not much more than spectators in a court watching so-called legal experts perform in front of a robed referee. Originally, American jurors were considered to be citizen judges who not only watched over the robed judge and attorneys, but who were especially committed to ensuring that justice was done in every courtroom. To see a biblical basis for citizens acting as judges in this manner, refer to 1 Corinthians 6:2. "Do you not know that the saints will judge the world? If the world is judged by you, are you not competent to constitute the smallest law courts?" From the beginning, American juries had a twofold responsibility: examine the facts in a particular case, and 2, judge the law at the center of the controversy. They understood that if a law was tyrannical, enforcing it would prevent justice rather than secure it. Consider what would have occurred if Daniel in the Bible had been a defendant in these early American courts. In Daniel's case, a law had been passed declaring that prayers could be offered to no one but King Darius. Daniel broke the law, prayed to the one true God, and was arrested. Daniel 6:7-16. In that case, If that case had been brought before an American jury in a court of justice during the 1600s, 1700s, or 1800s, Daniel would have been immediately acquitted. The law under which he was being tried would have been judged unjust and despotic, violating Daniel's inalienable right to pray to his God according to the dictates of conscience. Even if the judge had told the jury that Daniel had definitely violated a clearly written law and that the jury must therefore return a verdict of guilty, the judge's instructions would have been ignored. The jury was in check and balance on the judge to ensure that justice was done, and therefore it had the right to judge both the law and the facts. Juries in the early America often shone brightly in this regard. For example, during the Massachusetts witch trials of 1691-1692, 19 defendants were convicted and sentenced, and 8 others died in prison as a result of awaiting trial. But then juries stood up and acquitted or released the next 52 defendants, often in opposition to direct instructions given to them by judges. In 1735, newspaper publisher Peter Zinger of New York was taken to trial for his printed attacks against Governor William Cosby. British law at that time forbade anyone from criticizing a British official, even if the criticism was truthful and valid. The judge therefore instructed the jury to convict Zinger for criticizing the governor, but the jury ignored the judge and acquitted Zinger, believing that any law that punished citizens for telling the truth was unjust. As the American Revolution approached, American juries refused to convict defendants under the British Navigation Acts, which treated American merchants and entrepreneurs as smugglers and criminals. The British responded by creating courts of admiralty from which juries were excluded and in which the accused was considered guilty until proven innocent. John Adams denounced this as a most grievous innovation and thundered, "In these courts one judge presides alone. No juries have a concern there. No juries, thus no guarantee for justice." When America separated from Great Britain, the founders specifically enshrined juries, both the federal and state constitutions. To ensure justice was secured, juries were empowered to judge both the law and the facts. Therefore, an American court's attorney and judges argued all issues about the law and evidence in the presence of the jury so that the jurors would be privy to all the facts. As one legal expert observed, judge and jury heard the same evidence and might disagree in interpreting it. But in the years leading up to the 20th century, a dramatic shift occurred, with courts of justice devolving into courts of law. Upholding the law replaced the pursuit of justice. The impetus for the change was a series of jury decisions against the megacorporations and monopolies of that day, after which several powerful legal groups began lobbying Congress and the Supreme Court to limit the power of juries. In 1895, the Supreme Court ruled that juries would no longer consider the law in the case, but only the facts. No longer would they serve as a check against the tyranny of bad law. Rather, they would only be asked to decide whether an individual had violated a law, even if that law was unjust. In that same period, Congress passed a law birthing the federal courts of appeals system. There had previously been no need for such a system, for juries had always been the final word. In the new federal court of appeals system, judges began to tell one another, and the judges below them, what the law was. Judges had taken control of the law and become its sole interpreters. Juries were still involved, but the judges now controlled the juries. Juries were no longer privy to all the facts and evidence, and many of the legal arguments began to occur outside their presence, either in the judges' chambers or in written arguments to which the jury was no longer given access. Juries received only the information that judges allowed them to know. The judge had replaced the jury as the most powerful force in the courtroom. Consequently, had Daniel been tried by a 20th century court of law, he definitely would have been convicted. The judge would have told the jury what the law was, that Daniel had violated the law, and that he must therefore be convicted. Nothing was more important than following the law as interpreted by the judges. In fact, if a jury tried to exercise its traditional historic role of considering not just the facts but also the law, judges were told to declare a mistrial or overturn the jury verdict. In the latter part of the 20th century, yet another devolution occurred, this time moving downward from courts of laws to nothing more than courts. According to the current legal definitions, a court is now merely a local or a body to settle disputes. Securing justice was the original objective of courts, then it shifted to upholding the law, but now it is merely settling disputes and ending arguments. Hence, modern courts have shown an eagerness to strike down laws that stand in the way of settling a dispute, preferring instead to impose their own judicially crafted policy that they believe best ends the disagreement. Under this arrangement, the people's role in the judicial system is the smallest it has ever been in the history of the Republic, and justice has been the casualty. But justice is important. It is a biblical concept, and not surprisingly, since so many components of traditional justice are biblically derived, as America has become increasingly secular over the past century, the pursuit of justice has diminished. Americans need to regain the knowledge and understanding of biblical provisions for justice in the courts. They should also seek and accept every opportunity to serve on a jury, for biblical-minded citizens serving in courtrooms can help restore justice.